Good evening, folks. Welcome to Thursday night. We actually postponed the show. There was so much going on X that, and also end of the month with some of our jobs. That we just pushed it one day to be ready. But we've got in the studio with us tonight. We've got Big Ron, our producer for the Grand Jury Show, and Bruce Wayne, also a producer for the Grand Jury Show. How you guys doing tonight?
Having a good night tonight, Joe. Looking forward to see part two of this. See what's going to go on with the prosecution and the defense, and see where we go. What direction's going to happen?
Yes, sir.
Yep, and we got a little bit of a recap we'll go into in a moment. But for those of you that are just joining us, or maybe your first time watching, this is our night court show, as we call it. We bring you real criminal prosecutions, real criminal court trials, jury trials. We show you the evidence that a jury sees, and then you get to see it sit as a jury member. Unlike what we do with the grand jury, every Friday night we bring 5 fresh folks on each week, and we do a decision right then and there. This is a little different. It takes a little while to get through the jury. You got to listen to all the testimony. You've got to hear all the hearings and the decisions made by the judge that affect the jury and the jury's instructions. So what we're going to do is, and we're going to run these in episodes. We started with episode 1 last week, and we'll recap that in case you missed it. But at about the 5th episode, it looks like it's going to be, we're going to bring in a 12-panel volunteer jury that watched all the episodes and come in and let them deliberate and decide what they would decide, and then we'll reveal the real jury's verdict on this particular case. But what we're going over with, this is a case out of Texas over a short-barreled firearm. I believe the actual statute reads something like possession of a prohibited weapon because it's, quite frankly, too short. And this is a felony offense. This is a gentleman that's on the hook in the great state of Texas. It could go to the penitentiary for the possession of this shotgun. But with that, if you're just watching, go back and catch the previous episode. Stay up to date. We'll select a jury from our Patreon members, paid tier members first. We'll select them. Let me throw that up there because that could be interesting for everyone to know. If you want to be on this jury, actually, hit that QR code, join our Patreon group, become a paid tiered member or a support tiered member, as we call them. And you have the opportunity to be on the jury come the 5th episode, which will be a 2-hour episode so we can get through the deliberations. And we'll also reveal the jury's verdict on how they decided to see how close you would look at the case. But I tell you what, gentlemen, why don't we go with a recap from last week's testimony?
We are now on record cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. And as I told you yesterday, Mr. Young, if you'll please rise. Mr. Hartwell, if you will present the indictment to Mr. Young.
In the name and by the authority of the state of Texas, the grand jury for the county of Van Zandt, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2021 of the 294th Judicial District Court for said county, upon their oaths present in and to said court at said term that Reginald Hoyt Young II, hereinafter styled defendant, on or about November 25th, 2020, and before the presentment of this indictment in the county and state aforesaid, did then and there, intentionally or knowingly, possess a short barrel firearm, to wit, an Eastern Arms 16-gauge shotgun, against the peace and dignity of the state, signed foreman of the grand jury.
Thank you, Mr. Hartwell. And Mr. Young, how do you enter a plea?
Not guilty.
Not guilty?
To be really kind of blunt about this case, it's fairly straightforward. On November 25th, you'll hear evidence that deputies with Smith County Sheriff's Office was investigating another incident that happened in Smith County. You'll hear that Mr. Young was not the subject of that investigation. In fact, the subject of that investigation was a man by the name of Russell Melton. However, during the course of their investigation, the deputies with Smith County were led to the property that Mr. Young resided on. You'll hear that they found some evidence from that Smith County incident on the property. And as follow-up, they got a search warrant and searched the property, where they found a sawed-off shotgun. Good afternoon, Investigator McDonald. Can you please start by introducing yourself to the jury and spell your last name for the court reporter?
Absolutely. Tim McDonald, Tim McDonald.
Can you tell me what the basics of that investigation was?
Yes, we were investigating a burglary that took place in Smith County.
What was found as a result of the search warrant?
We located a firearm that was found to be a violation of Texas law.
Mr. Stevens, your witness.
Thank you, John. Investigator McDonald, I'm Bill Stevens, going to ask some questions. If I don't make myself clear, just please stop me, okay?
Yes, sir. Thank you.
All right. Now, how did you derive at the fact that Mr. Young lived at that travel trailer? Other than his statement, was there any evidence that you found that tied him to that travel trailer?
Yes.
What was that?
His vehicle parked.
His vehicle?
His vehicle was parked in the vicinity.
Okay. So because his vehicle's parked there, that means he lives there? Your investigation, he was not the target of your investigation, correct?
That's correct.
Okay.
He was not.
And to your knowledge, was he arrested for anything other than the sawed-off shotgun?
Not that I'm aware of.
Okay. What was the investigation all about that led you out to that location?
It was a burglary of a habitation that occurred in Smith County.
And what kind of property were y'all actually looking for?
We were looking for gold, coins, and other precious metals, firearms, and items that were specifically taken from that specific residence in Smith County.
You mentioned earlier that you overheard him state that he lived on the property. Can you clarify the circumstances around that statement?
Yes, he was willing to speak to detectives and other officers there, and while he was talking, he advised that the RV travel trailer was where he resided.
Okay, there's your recap from last week. We had the reading of the indictment, the opening arguments, some of the stuff that's very formal in a criminal trial, a jury trial. We saw that. We also got into the first witness, and you saw some examples of what the first witness said. He's a detective. Now, this case actually is in one county, but started in an adjacent county next door through a burglary that led officers into this other county looking for items that were stolen in a burglary and an attempt to recover and arrest the perpetrators of the burglary. And they wound up going to an address, finding a gentleman there that was never charged with the burglary, wasn't charged with possession of anything from the burglary, and they found him to be in possession of a shotgun that was shorter than the legal limit, making it a prohibited weapon and making, I think the technical charge is possession of a prohibited weapon. It's a felony charge, pretty serious charge in the state of Texas. This man is looking at 5 to 10. He could be looking at with some enhancements, but 2 to 5 is probably a more appropriate range, as long as there's no other offenses or anything they can enhance it on if he were to be found guilty. So it's an interesting case, not a homicide like we normally see. It's like one of the police shootings we watch on Friday nights. But this is very interesting, and I want everyone to keep in mind, I have edited out. The only things that you are seeing and hearing are exactly what the jury that made the decision is seeing and hearing. No sidebars, no motions heard outside of the presence of the jury, no media. So this is rare. You make the decision off the testimony that you hear. Tonight, we're going to get into what we heard. I told you the two counties. One is Smith County. The other is Van Zant County. We're in a Van Zant County courthouse. The first episode was a Smith County deputy who was pursuing an investigation into a burglary in his county. But the final charge for this possession of a short-barreled shotgun, possession of a prohibited weapon, is in the county where they found it, which is in Van Zandt County. So now we're going to hear from the second testimony. Is going to be, this guy's going to have a lot more detail. He's a Van Zandt County a criminal investigator from the Van Zandt County Sheriff's Office. He's going to provide more detail, and the crux is on him. He's the arresting officer, essentially. The other officer explains how we got there, and when we got there and found these fresh offenses, he says, hey, we called the Van Zandt County Sheriff's Office. They come out and said they were interested. They picked up the case and the evidence, and they moved on with it and filed the case for prosecution. So with that in mind, hey, you know what? We've got Fred. We got Fred. Fred, I'm going to bring you up on stage real quick before we get started. Fred's one of our Patreon support tier members, and he has carte blanche on the show. He can watch it from front stage, backstage, but he also has the opportunity to be a juror into this. So everybody watch this one coming up. This is going to have a lot more detail in it. Now, I'm going to warn you, there's a portion in here where they go to an audio tape, and they're watching. They've also got on a screen that we can't see some pictures, and they're going to talk about it. So listen to the testimony. You're not going to be able to understand the audio very well, but listen to the testimony, and they'll explain what they're hearing in there, and you make your judgment as whether you actually believe it or not. But it's going to get a little more interesting tonight. We're going to see the shotgun. We're going to see some more details of the investigation that we didn't see with our first witness. So first witness warms us up. Second witness gets us started. Episode 2, grand jury, going now.
Does the state wish to call another witness?
Yes, Your Honor. The people will call Lieutenant Bob Keltner.
Lieutenant Keltner. Sir, if you'll raise your right hand, do you swear that the testimony you give to the court today will be the truth, whole truth, and nothing but the truth, so help you God? What's your step? Do your testimony supporting that you speak up loudly and clearly so that everyone can hear what you have to say. Allow the attorneys to finish their question before you start speaking, so we're not talking at the same time, which makes it difficult. Okay. Mr. Hernandez.
Thank you, Your Honor. Good afternoon, Lieutenant. Would you please introduce yourself to the jury by stating your full name and spelling your last name for the court reporter?
Okay. Good afternoon. I'm Robert Aaron Keltner, Keltner. I often go as Bob.
And Lieutenant, I mentioned Lieutenant Bob Keltner. Is that your current title?
It is.
And which agency do you work for?
Van Zandt County Sheriff's Office.
And how long have you been with the Van Zandt County Sheriff's Department?
Almost a year and a half this time.
This time? So you have some prior law enforcement experience?
Yeah, I had a break in between 2021 and 2023.
And are you a post-certified peace officer?
I am.
Okay, and when did that certification first start?
I got my basic in 1991.
Okay, so how many years total in law enforcement have you had?
A little over 30. I had a break in the late 90s.
And what other agencies have you worked for?
I worked for the constable's office here, Precinct 4 in Van Zandt County. Been there almost 15 years, dual commissioned. And then, of course, the sheriff's office from 2017 to 2020. McCullough County Sheriff's Office in Brady, Texas. Did a short stint with the Van Police Department here in Van Zandt County, and the Kemp Police Department in Kaufman County.
And so fair to say that you've kind of come up the ranks and you started off as a patrol officer initially?
That's correct.
Okay. And when did you receive your commission for lieutenant here in Van Zandt County?
June of 2023.
Okay. So asking you to look back on to November 25th, the year 2020, were you working for the Van Zandt County Sheriff's Department?
I was.
Okay. And in what capacity? What title?
I was a sergeant investigator with in the Criminal Investigation Division.
And what were your duties in that capacity on that date?
I strictly worked property crimes or major crimes when it was necessary.
Do you have occasion to respond to 1255 Van Zant County Road 4910 in Ben Wheeler, Texas, back on November 25th, 2020?
So I did.
And was that location there and now, sir, in Van Zant County, state of Texas?
Yes, it's in rural Van Zandt County.
Talking about middle of the day, maybe about 11:30, maybe noon. Does that sound about right?
Yeah, it sounds about right. We were there a good part of that day.
And how is it that you were called to that location?
The Smith County Sheriff's Office was investigating a property crime that occurred in their area. And they had ended up, as a result of their investigation, on 4910. And they requested us to come assist them, which is often the case when you're in somebody else's jurisdiction. You talk to who works there,
So-
at the very least to let them know.
Because they were from Smith County coming into Van Zant.
Yes.
I believe there was testimony about a courtesy call. Is that what he was referring to?
Yes, that would be the case.
Okay. And upon arrival there at that location, who did you meet with?
Met with Deputy Kevin Londoff and Deputy Tim McDonald with the Smith County Sheriff's Office.
And did they advise you of the purpose of their call and why they were at that location?
They did.
And as a result of that, what happened?
So they were there, like I said, investigating a property crime, which was a burglary. They had had a significant number of gold coins stolen out of a safe in the northwest portion of their county. And they had followed up some leads that led them to that location. And they had two individuals that they had detained there and were trying to forward their investigation.
And at any point, were you able to observe whether they were actually conversing with those two individuals?
I believe so. They were talking
Okay.
to those folks.
And one of those individuals, do you see that one of them here in the courtroom today?
I do.
Do you see Reginald Young, the second, here today?
Yes, sir.
Would you please describe where he is seated and what he is wearing?
He's seated here next to his attorney in a button-down shirt with his glasses on.
Your Honor, I'd ask the record to reflect identification of the defendant by this witness.
The description is a button-down shirt with glasses on, sitting next to an attorney. I'm not sure that that's a sufficient identification because they're both wearing button-downs. They're both wearing glasses.
Okay.
There's no presumption that one's an attorney over the other.
Okay.
Do you see somebody wearing a suit?
Yes, I do.
And who is that? Do you
I
know?
would assume that is his defense attorney.
Okay, and the person sitting to his right.
It is Reginald Young, a person I know is Reginald Young.
Okay, you know him as Reginald Young.
Yes.
At this time, I'd ask the record to reflect identification, Your Honor.
All right, record will reflect that this witness has identified the defendant, in this case, Reginald Hoyt Young II.
Now, Lieutenant Keltner, I'd like to ask you about body worn cameras going back to November 25th of 2020. Were those in use at the time by the Van Zant County Sheriff's Office?
I believe that I had one issued to me there in that time. Yes.
Okay, and do you recall if that body worn camera was used by you on that date when you responded to that call?
I don't recall. We were leading up to the transition from one administration to the other. I don't remember whether I'd turned it in or whether I was wearing it that day.
And do you recall anything about CID and whether or not there was a policy as to whether body worn cameras would be worn by those investigators?
I don't recall a policy requiring CID to wear them at that time.
Okay. And so to your knowledge, did the deputies interview the defendant, Reginald Young, at that location?
I know that they did talk to him. Yes.
And as a result of that investigation, do you know if any of the alleged stolen property was found on scene?
As I recall, he did not consent to a search, so they were required to get a search warrant to advance their investigation there.
And was a search warrant obtained to lawfully conduct a search on that property?
It's my understanding that the Smith County Sheriff's Office, those deputies that were out there, had obtained a search warrant for that location. Yes.
And did you participate in any way with the processing of that area after the search warrant was signed?
Oh, yes. I assisted with searching a vehicle and other locations. Yes.
I may approach the witness, Your Honor.
You may.
So Keltner, I'm handing you what's been marked for identification purposes as States Exhibits 1, 2, 3, 4, and 5. Without actually displaying them to the jury, I'd ask you to take a look and see if you recognize those.
Yes, I do.
And what do those purport to be, sir?
All right, number one is looks like an upright freezer.
Now, well, let me ask you a more general question. Are those all photographs? Do they appear to be photographs?
Yes, all 5 of them are photographs of what I recall to be the location of the search warrant.
Okay, and do they each and every one of those, 1 through 5, clearly show the situation and what you observed back on November 25th, 2020?
Yes,
They've not been changed or altered in any way?
not to my knowledge or detection, no. They look just like what they did back then.
At this time, I'd move for the admission of States Exhibits 1 through 5, Your Honor.
No objection, Your Honor.
All right, there being no objection, States Exhibits 1 through 5 are admitted.
I may approach the witness, Your Honor. We'd like to ask permission to publish at this time.
Yes, sir, granted. And Mr. Alternate, sir, Mr. Alternate, if you want to, you're welcome to bring your chair out. You can slide your chair out here so that you can get a better view so that you're not having to crane your neck up. Deputy Martinez, if you'll help me.
If I may, Your Honor.
Yes.
Lieutenant Keltner, so you would stand identified now and marked as States Exhibit 1. Started to comment on that. What is that item?
It appears to be a stand-up freezer that was against the travel trailer at that location on 4910.
Okay. And do you recall what the makeup was? There's been a travel trailer discussed and a mobile home as well. Are those two separate
Yeah,
living quarters?
yes, two separate residents, I guess, or living quarters, yes. Two
Okay.
separate.
And this refrigerator or freezer, I believe is how you refer to it,
Uh-huh.
is in front of, is that the RV?
Yes, the RV travel trailer, yes.
I'm going to show you States Exhibit 2.
Mm-hmm.
Is that same freezer?
That's
Door
the-
open?
Yes, it's the interior of it, yes.
Okay. And do you recall seeing, what is the item there on that center shelf?
That's the breakover shotgun in question today.
States Exhibit 3 here, it's more close up. You see that there?
Mm-hmm.
Is that the same shotgun you're referring to?
Yes, it is.
And to your recollection, was there another firearm that was also located?
There was.
States Exhibit 4. What is that there?
It's a 22 long rifle with a scope on it.
That's this here.
Mm-hmm.
And is that where it was located once law enforcement went into that RV?
Yes. Now,
Close up here, States Exhibit 5. Right.
yes.
Now, who actually took possession of these two firearms, Lieutenant Keltner?
I believe I did. And I transported them back to the sheriff's office in Van Zandt County.
Back on States Exhibit 3. Let me approach the witness, Your Honor.
You may.
Lieutenant Keltner, I ask you just to take a quick look and make sure that this item is safe. Ask you to identify it, please.
Okay, it is safe. This is a breakover shotgun that has been had the stock removed and the length of the barrel, or a length of the barrel.
And there's been some mentioning of a sawed-off shotgun. Is that the item in question?
That's how I would describe it. Yes, it does appear that the barrel was sawed off with most likely a hacksaw or something to that effect. That's what it appears. It doesn't. It's not clean. It does not appear to have been professionally modified.
Okay. Are you aware of instances where an item like that, a shotgun, can be professionally modified?
Yes, I would think so. I would think a gunsmith would be able to professionally modify a gun like that.
Now, are you aware of what the definition of a prohibited weapon is, Lieutenant?
Not verbatim, but yes.
Okay. Well, in measurements, what are we talking, and what would you be looking at?
The barrel should be at least 18 inches long, and the overall length should be 27 inches long, minimum. Otherwise, it requires a special permit or tax stamp.
And that's actually the item that was recovered from Reginald Young back on November 25th, 2020.
That is correct.
Does it appear to have been changed or modified in any way other than the identifying information that's attached to it?
No.
Your Honor, at this time I move for the admission of State's Exhibit 6.
Objection to state 6.
Oh, it's the sticker. It's
Oh,
the-
no objection, Judge. No. All right, there being no objection, state's exhibit 6 is admitted. Deputy Martinez, will you get this from Lieutenant Kelton?
Make sure.
Let me approach the witness, Your Honor.
Yes, sir, you may.
Lieutenant Keltner, I'll ask you to take a look at what's been marked for identification purposes as State's Exhibit 7. It's a box currently there. Can you take a look to see if it bears any identifying information?
It does.
And whose name appears on that box?
My name appears on it.
Okay. And do you know when that box would have been put together in that fashion?
Well, I collected it on November the 25th, 2020. I did not box this particular piece of evidence myself.
Okay. But you actually brought an item from Mr. Young's residence back to the Sheriff's Department.
That is correct.
At this time, I'd ask you to go ahead and break the seal on the box and then look at the contents without actually pulling out that item.
The seal is already broke on it.
Okay? Does that look to be fairly the same item that you recovered back on November 25th, 2020?
Yes.
Has it been modified, changed in any way?
It appears that the scope has been removed from the top of the rifle.
Okay.
This is my handwriting on the tag.
If you wouldn't mind just taking a quick look and making sure that it is safe.
Can I cut it out of the box?
Yes, you need Deputy Martinez's eye.
No, I have one if that's all right.
Yes, you can cut it out.
I believe the weapon is safe.
All right.
It is on safety.
Your Honor, at this time, the state would move for the admission of State's Exhibit 7.
Any objection to state 7?
Your Honor, I got a couple of questions of the witness on State's Exhibit 7.
All right, go ahead.
Officer, you testified just now that the seal had been broken on the box.
Yes,
Okay. Did you break the seal?
I did not.
Do you know who broke the seal?
I do not.
I'll object to the admission of this evidence, Your Honor. Seal's been broken. He doesn't know who broke the seal. We don't know if that was actually the weapon put in there at the time.
Response from state.
I believe he testified that it is the weapon, Your Honor, that was placed in the box, other than the fact that the scope was taken off the weapon. That was the testimony.
All right, then the court will overrule the objection and state 7 is admitted.
Please note my objection.
Yes, sir. It is noted for the record.
If I may approach the witness, Your
You
Honor.
may.
Seal it up.
You just laid on the floor.
All right, sir. Thank you. Now, Lieutenant Keltner, I'll make reference back to State's Exhibit 6, but it has been admitted there. And handing you a standard Stanley 12-foot measuring tape.
Okay.
You testified to the fact that there's a certain length that you're looking for and what qualifies as a prohibited weapon. What was that number in terms
Anything
of
under
barrel
18.
length?
Anything under 18 inches.
Would you please take a moment and measure the length of that barrel there?
Shows a 16th over 11 inches.
So that's almost
11
7
inches.
inches.
Yeah, 11 inches and a 16th,
And it should be
18 inches. So it's well under.
7 inches.
Yeah.
I think even I can do that math.
Uh,
All right. And then you also stated that there was a overall length that you're looking at.
of 26 inches.
And would you please just take a moment and measure that?
this case, Reginald Boyd Young. Where you just stayed on the floor. All right, sir.
Thank you. Now, Lieutenant Keltner, I'll make reference back to State's Exhibit 6, but it has been admitted there. And
I'm not sure what happened there. I don't know if I've got a short render or I think I do. Wow. Folks, my apologies. I do not have time to go in and pick up the rest of this, I don't think. You know what? Give me just a second. Give me just a second. You guys talk or something.
Well, honestly, I hardly even noticed that it was paused for a second because the guy took so long to analyze all the evidence. Yeah. So
Well-
for a good minute or two there, I was staring at it like thinking he was just reading.
I think the defense had a good point there at the beginning of the fact the box has been tampered with, that the person didn't break the seal. So how do they know if that's the actual weapon that was submitted? The judge overruled it, but I think that was a good point by the defense.
Well, the defense didn't finish it up. He's right. The seal was broken. Who broke it? Should be a chain of custody. But what else was in the investigator's testimony that he should have questioned that he didn't? In my opinion,
The weapon was modified. Probably being put in the box. It had parts taken off of it.
no. What he
That's
said
one thing
was, well, I don't know who put it in the box, but that's the weapon I brought from the house. So he didn't know who boxed it. He didn't know who took it off. He don't know who broke the seal. I think it was good. I think it would have been a good challenge.
Yeah, I do too. I do too.
I'll tell you, I'm not real impressed with this guy's investigation. He's a lieutenant. He's in charge of the Criminal Investigations Division for Van Zandt County. And Van Zandt County is pretty rural, so I'm going to give him a little slack. But he doesn't testify well, in my opinion. I thought it was interesting that he had to be coaxed to be able to give a description of two people sitting at a table.
Yeah.
You remember this?
Yeah.
I got a chuckle out of that too, Joe.
All right, hang on, I'm seeing what's going on here. All right, folks, bear with me. I'm going to try to render this again and see if I can get all of it. I don't know why it didn't render out. Give me just a minute. It shouldn't take but maybe 2 or 3 minutes.
Maybe, Ron, that should give you just enough time to sing an opera. Keep us entertained. But no, I tend to agree with Joe. Not great at testifying. Not that I've seen a whole lot of these, but
Man, oddly enough, I've been in court a lot, and I've listened to a lot of other testimony, whether it be waiting on a warrant. There was a time period where I worked called jail transport. I was certified peace officer, but there were no spots on the street for me. So instead of being a jailer, they kind of is a good position where you take inmates back and forth to court hearings and trials and things like that. So I've had the opportunity to listen to a lot of people testify, and I've testified quite a bit myself. You really, it's one thing. It's nerve wracking. I don't care how many times you've done it. Every time you get up there, you're nervous because you are being scrutinized, 100%. Whatever you're answering with one side, the other side is going to come back and try to cross you on that.
NC says he doesn't seem confident. Do you think that's just that he's not real good at speaking, or he's not real sure about what he's saying?
You want my public opinion or my real opinion?
Well, anything that won't taint the jury.
I'm not going to give one then. I think he
Alright,
could be
fair
better at giving testimony. Yeah, because I almost tainted the jury pretty. I may have done it already, but we'll see. So many people are watching. Maybe that's it right there. You can go back and find this. I'll give you a hint. I don't think he's very bright. All right, we're at 34% rendering. It's moving pretty good. I tell you, I've been cutting this so close that I've done it in maybe 10 or 20 minute increments going back since Saturday. Still learning to use the DaVinci software, so that I think that slows me down a little bit. But what do you guys think? Can you tell a difference in the effects? I mean, viewers may not, but you co-host should pick up on some of that, right?
Nah, I
Yeah,
can. I think it looks great. Much
Yeah,
smoother.
It's
Sorry,
it's
Ron.
definitely no, you're fine. You're fine. It's definitely a step up in the world with the graphics and the intros, the outros, the backgrounds. So it's only due to get better, folks. Only due to get better.
I think the smoke looks smokier.
I don't think I did anything to the smoke. The background is still with the old software. The only, and I'll tell you, I like DaVinci, but it's like being in the cockpit of an airplane. You need to know what every switch does. So right now, I know what a few switches do, and I think I can get it off the ground, but I need to learn what the rest of the things do. And we're working on it. More you do, the more you know, right?
Yes, sir. Yep.
And I'm gonna give you a preview since I've screwed up this video. I'm gonna give you a preview. Watch it tonight. I'm gonna make it easy for you. He's gonna bring up a point that the shotgun that they're charging this man with, and they didn't charge him with possession of the 22, the long rifle there that was objected to. They didn't. They're not charging him with that. His only charge on this indictment is possession of a prohibited weapon, which, i.e., a short barrel shotgun under 18 inches length and barrel over 26, under 26 overall. But yet they still introduced that rifle in there, which I thought was. I think the defense could have protested that all a bit. You're not charging him. There's nothing illegal about that rifle. Why you got it here?
I'd like to see what the shotgun looks like. I'm curious to see what the back grip is, because that's going to mean a lot depending on how that back grip is shaped.
It's shaped like you think it's shaped. It looks like a sawed-off shotgun.
Okay.
So,
and that's another thing too. He goes through a bunch of pain to explain that. Well, it looks like you Hawks. So what is it? What would you use? I would think, and he kept saying, "I would think." I would have objected. I'm not. I don't care what you think. You're here to tell us what you know. You know, expert on firearms or how they're modified. Who are you?
You really couldn't even verbalize what a prohibited weapon was. But help me fill in a piece I missed. So somehow that firearm got boxed between when he discovered it and when it made its way into custody or evidence. Like, is that something that happened? They don't know who boxed it?
I'm sure there is a chain of custody form that it says that here's the way it works. If I'm out on a crime scene and I pick up a shotgun that I say it's evidence for some form or fashion or manner, you're going to mark it. A lot of times it's a firearm with a wooden stock. I'll put a mark, and I know what the mark is. I'll put a mark on it and take a picture of that. Typically, you put it in some sort of a packaging, plastic, wrap it in paper if you have to, transport it back to the station or your evidence room. Every agency's got a kind of a room with lockers in them that you can put stuff in, but you can't get stuff out. If that makes sense, right? So whatever you put in there, once you lock it, you don't have a key to get it out. Only one person or two people in the whole agency have a key to get it out. And they'll come in and take these once a day, like during the day. They'll start processing evidence. They'll take that. For every person that it goes to, I would do the first chain of custody form when I get back to the station. I would take it out of the paper, and you do want it in a box like that. And then what he's cutting are zip strips. That box has holes in it. So when you lay a firearm, it's got a bunch of holes. So you can put some zip strips in there to keep it from banging around. So they'll have that type of material there at the station where you're doing the first lockers, right? So I'll fill out the first form saying I took it from 12345 Main Street. I brought it to 12345 Police Street at the evidence room located at whatever room or hallway, however that's designated. And then I'm going to go into where I prepared it for packaging and stored it in locker number, whatever locker I'm going to put it into, whatever it'll fit into. But I'm going to package it up. I'm going to put the zip strips on it. I'm going to close the box, and I'm going to put the tape on it. Now, is it wrong if I were to take it back and hand it to someone? Hey, can you go log this into evidence for me? Yeah, sure. Give me the details on it. And there you go. So I give him the details from me to him. Then when he picks it up, he'll say, Investigator Joe gave me this at this time and asked me to log it into evidence. I agreed. I took possession at this time. I traveled to there, and then he'll fill it out. When the person comes and unlocks the locks and they get that piece of evidence out, they'll say, on this day, I went to locker number whatever, and I opened it up, and the same sheet's traveling with this item all the time. So it's just another line. I got it this day, and I did this with it. They'll take it and they're going to log it in somewhere else where it'll be logged again. If it goes off forensic evidence, it's always going to be logged again. When they go to court, most likely he was responsible to go to the property room, take the evidence for this case that's been requested by the prosecution, and he brings it to court with another form, and then he'll hand it off to the DA, and the DA will actually be the last person on the chain of custody when he hands it back to you. So there should be no time where anybody touched that and you don't know who that person is. So I think it was a good objection, but I think it could have followed up and made it a little stronger. I think the judge would have gone for it because, not only is it seal broken, but you also said you didn't box it, and we offered no explanation for that. All right, folks, I think I've got the full one up here. I'm going to try to fast forward it into, I'm not sure exactly what time we're at. We're at staring at the shotgun. Is he still trying to get does he have the shotgun, or he still has the?
He had declared it safe, and I believe he'd put it down. He was reading a piece of paper.
I think he was getting ready to measure it.
Not to my knowledge or detection, no. They look just like what they did back then.
At this time, I'd move for the admission of. See that there?
Mm-hmm.
Is that the same shotgun you're referring to?
Yes, it is.
And is that same freezer?
That's
we're open?
Yes, it's the interior of it. Yes.
Okay. And do you recall seeing what is the item there on that center shelf?
Have we heard this? Am I too far?
No, I think we're good.
Yeah, I think we're good here.
That's the breakover shotgun in question today.
State's Exhibit 3 here. It's more close up. You see that there?
Mm-hmm.
Is that the same shotgun you're referring to?
Yes, it is.
And to your recollection, was there another firearm that was also located?
There was.
State's Exhibit 4. What is that there?
It's a .22 long rifle with a scope on it.
I think I'm early.
That's this here.
Mm-hmm.
Yeah, you need to go forward, Joe.
Okay, it is safe. This is a breakover shotgun that has been had the stock removed and the length of the barrel, or a length of the barrel.
Did you see the stock when he raised it in his
And
right
there's
hand?
been some mentioning of a sawed-off shotgun. Is that the item in question?
That's how I would describe it. Yes, it does appear that the barrel was sawed off with most likely a hacksaw or
Yeah,
something to that
most
effect.
likely.
The barrel should be at least 18.
State's Exhibit 6.
on it.
Okay. And do you know when that box would have been put together in that fashion?
Well, I collected it on November the 25th, 2020. I did not box this particular piece of evidence myself.
Okay. But you actually brought an item. Look to be fairly the same item that you recovered back on November 25th, 2020?
I believe the weapon is.
Any objection to state the seal?
I did not.
We testified that it is the weapon, Your Honor, that was placed in the box, other than the fact that the scope was taken off the weapon. That was the testimony.
All right, then the court will overrule the objection and state 7 is admitted. Please don't by judge. Yes, sir. It is noted for the record.
If I may approach the witness, Your
You
Honor.
may.
Seal it up.
You just laid on the floor. All right, sir.
Thank you. Now, Lieutenant Keltner, I'll make reference back to State's Exhibit 6, but it has been admitted there. And handing you a standard Stanley 12-foot measuring tape.
Okay.
You testified to the fact that there's a certain length that you're looking for and what qualifies as a prohibited weapon. What was that number in terms
Anything
of
under
barrel
18.
length?
Anything under 18 inches.
Would you please take a moment and measure the length of that barrel there?
Shows a 16th over 11 inches.
So that's almost
11
7
inches.
inches.
Yeah, 11 inches and a 16th,
And it should be
18 inches. So it's well under.
7 inches.
Yeah.
I think even I can do that math.
Uh,
All right. And then you also stated that there was a overall length that you're looking at.
of 26 inches.
And would you please just take a moment and measure that?
Did we freeze up again right at the same spot?
You know what? I'm already on it. I think it's doing it again.
Can you skip ahead just 10 seconds or a minute? Maybe get through it.
I'm cutting. I don't know what it is. The video's rendering correctly. It's something on StreamYard that's stopping it at that length. I don't know if I'm having an issue with. I don't know what it is yet. Hang on. I'm cutting the video in half. I'm about to render the second half for it.
Hey, Ron, were you able to see the stock of that shotgun this time?
Yeah, I saw the stock of the shotgun this time, and like Joe said, that was cut with a saw or something like that. And the reason I asked that question is the way the laws read for short barreled firearms, especially a shotgun. The end of that shotgun has a lot to do with it. It makes absolutely no sense. It's one more proof that the people who write these laws for the ATF don't have a clue of what they're talking about. But you can have a 10-inch shotgun as long as it doesn't have a stock and or a pistol grip on it. If it has a what we call a hog leg on the back end of it, it's completely legal. It makes no sense.
Well,
It
it
just
depends
is
on
what
the
it
state.
is.
In Texas, it's you can't have a barrel less than 18 inches. And even if let's say you have a barrel less than 18 inches and overall it's 30 inches, it still will be unlawful because of the length of the barrel. You can't cut enough of the stock off so that your overall length for concealability is less than 26 inches, I think is what it is. And that's literally what a short barreled a shotgun or firearm is in Texas. If one of those two are true, then it's a felony offense in Texas.
Yeah, in Florida, it's if you have that hog leg grip on the back of it, and then the I think the distance from the breech to the tip of the barrel is, I think it has to be more than 12 and less than 16. It falls.
Damn,
into
they make
straight
it
out
complicated.
category. Yeah, it's weird, but it's completely legal to have it. Then it's crazy. I'd have to verify the law though. Don't anybody quote me on that. I'd need to look that law back up. But yeah, that grip on the back of that shotgun has a lot to do with it.
Well, what got him, his barrel was under 18 inches, so it didn't matter at the back. So, I mean, you're done at 18 inches with a shotgun. All right, I believe I've got it rendered. Let's see if I can get this damn thing in here. And folks, I apologize. Technical issues and, and it being Ron's fault. He's the producer. Other than that, I don't have any other excuses.
Yeah, I'm working on it, guys. Sorry, 100% my fault. We'll get it going. We will get it going.
We might miss 6 minutes of this. I anticipated that was going to cut off a little closer to 27 minutes, and I think I've got this at 28. We won't miss much. Let's see where it's at. What the?
A Big Ron Carmen forgives you. She says it's all right.
Wait. How is that? It's not okay, Joe? Okay, Big Ron?
No, Ron
Ah,
took responsibility for that.
That's I don't know about that, Carmen. I'm
Thanks,
feeling a
Your
certain
Honor,
kind of way about that.
last question. Lieutenant, did you take any fingerprints from the shotgun?
I did not.
You did not. Do you know if anybody took any fingerprints?
Okay, I want to make sure everybody understands, and I think this is true. You just about saw the end of the state's direct examination, and they rested, and now the defense is asking questions. I apologize for the missing couple of minutes, but you missed the introduction. Hey, I'm the attorney. If I say something incorrect, you don't understand, please ask me questions. Bullshit.
Not to my knowledge.
Okay. Did you ever see Mr. Young possess? I mean, with your eyes, did you ever see Mr. Young possess the shotgun?
No, I did not see it in his hands or on his person. So no, I did not.
Okay. And tell us again where this refrigerator was located that had the shotgun in it.
Okay, so in the photograph that you can see there, there's what I would describe as a double wide trailer house. I believe it's a double wide, where Mr. Young's mother lived at that address. And then off to the east side, there was his RV that set not perpendicular, but at an angle to the double wide where Mr. Young was living. And I'm sorry, to more completely answer your question, there was a refrigerator in that stand-up freezer that was against the RV on what I would describe as the west side.
Okay. Was it on the RV, like on a porch, or was it on the ground?
I recall it being on the ground, not a porch. I don't recall an improved porch.
Well, so it wasn't inside the travel trailer itself, the refrigerator.
No, it was not on the inside.
Okay.
The freezer and the refrigerator were not.
Were there several travel trailers and whatnot in that general area that people lived in?
On that road, yes.
Yes, sir.
Yes, on that road, yes.
Okay. And how about on that particular property where you were?
I don't recall any other structures besides the travel trailer RV and the double wide. I do recall there being a shed on the west side of the property, but I don't recall anybody living in there. I believe it was for storage.
Do you recall a building or a house being tore down at the time you were doing your investigation?
I think that the storage building may be what you're referring to, but I don't remember it being tore down.
In the process of being demolished.
I suppose that's possible, but the structure appeared to be erect at the time. I don't recall it being.
Okay.
I mean, it's not like it was in pieces or anything. I remember it having 4 walls and a roof and having a number of items would appear to be in storage inside of it.
Okay. Is that sawed-off shotgun operable?
So I would not consider it operable at this time. No.
Looks to me more like a, I don't know, some kind of relic or something that you'd see hanging on a wall.
Perhaps.
Any idea do you have any way of determining the last time that shotgun was fired?
I do not. No, sir.
Okay. Did you go inside the property? I think you answered that. I want to ask you one more time. Did you go inside the property,
Okay. I mean,
the travel trailer?
I believe that I looked inside the travel trailer after they were done searching and discovered the rifle, but I didn't spend much time in there if I did.
Okay. I noticed on State's Exhibit number 6, I believe it is. I'm sorry, on State's Exhibit number 4, it shows the pick of the shotgun, and it shows a pill bottle on a table next to it. Did you happen to look at the pill bottle to see whose name was on it?
I don't recall doing that, no.
Okay. Pass the witness, Your Honor.
Hernandez, your witness.
Thank you, Your Honor. Lieutenant Keltner, in your 30 years of law enforcement experience, have you ever followed up and asked that an item be dusted for fingerprints if the suspect had admitted to possessing or moving the item?
Oh, no, sir, no.
And in this instance, did you feel it necessary to dust the sawed-off shotgun for fingerprints?
No, sir.
Why not?
Because possession was identified. It was not necessary to find an unknown person, as to who possessed it.
Did he in any way admit to ever having touched it?
He did admit to touching it.
What did he say?
He said he moved it from his vehicle to the location where it was discovered.
In the freezer?
In the freezer. I don't recall that he said it was a freezer, but he moved it out of his vehicle to that location.
Now, counsel asked you about a relic. In your 30 years of law enforcement, maybe even longer, have you ever come across an item that in your mind was a relic?
I would say yes.
How would that item appear to you?
As an example, I guess weapons and anything else that would be of age could be in a various degree of condition.
Mm-hmm.
Some things are in better condition than others. As an example, I've been to a gun store where they had a weapon that was documented to have been produced during or shortly after the Civil War. It was sold to the United States Army, and it had returned to the manufacturing plant to be modified, and then had returned to service. And somehow it ended up as in private ownership. And I would say that that's a relic or an antique, but it was still in serviceable condition, and it had paperwork to go along with it.
Is it fair to say that the term relic would make you think of something being hung on the wall?
I would think of it that way, yes.
It may have a plaque identifying dates of service.
Very possibly.
It would have paperwork for its authenticity.
Yes.
Counsel also asked you about whether that sawed-off shotgun is operable. What would it take for it to be operable?
Simply sliding a firing pin into position and loading it.
How long would that take to slide that firing pin?
Just a few seconds.
No further questions, Your Honor. I pass the witness.
Stevens, your witness.
Thank you, Your Honor. Lieutenant, could anybody without experience put a firing pin in there? Would they know how to do it?
Well, I don't know. That would cause me to speculate as to whether they would know how to do it. I would think that anybody who was capable of placing a round peg in a round hole would be able to figure it out.
So where would you get a firing pin?
I would think that any gun store, or that the firing pin may have become dislodged and may have been available with the weapon.
Did you locate a firing pin?
I did not.
Did you look for a firing pin?
I did not.
Pass the witness, Your Honor.
No, nothing further, Your Honor.
Objections. Excuse.
Your Honor, we ask that he remain subject to the rule.
Okay. Cool. So follow that. Subject to recall, like the state.
Okay, so I can go vote?
Yes, you will.
Okay, all right. Thank you very much.
Yeah, you're free to go about your job. Just know that they call you, they can store in the rule not to discuss the case or discuss it with anyone else. That's on the paper.
There you go, folks. That's the second episode. Is horrible and the worst production ever, but I think we got it all in there. Interesting. There's no firing pin in the shotgun. He says it's just as easy as putting a round peg in a round hole. Is how easy it is to put it in the shotgun. What do you guys think about that?
I think I would disagree with that when it comes to firing pins and shotguns. Definitely need to have a little bit of knowledge about the firearm to get that firing pin in there, because you do have to disassemble the gun a little bit more than that to get to that firing pin and spring catch lever in there.
Why do you think they're bringing that up? Well, let me tell you this. I'm not going to go that route with it, but let me tell you that there we go. The one of the elements of the offense in Texas is that the firearms are operable, because you can have grandpa's stagecoach gun over your fireplace as a decorative item. That's not illegal. It's got to be operative. And then this is also why they brought up the relic. I think relic was a bad term. Trophy. Even used maybe the example of grandpa's shotgun over the fireplace because it looks cool. You have the right to do that, because the element of the offense is that it's that length. It meets one of the lengths that we talked about. Let's see, what's he saying? Put a stock on it. Changes the definition back to an SBS short-barreled shotgun, unless you fill it out. I think in Texas, there's no situation where you can have a shotgun under 18 inches in barrel length and overall length of less than 26. In Texas, and this is a Texas. We're not talking about federal law. So, my point is that I don't know that the defense drove that home the way I would have liked them to see that. He didn't ask the detective, the investigator, because he started to say, well, where would you get a firing pin? Well, I wouldn't know. If you won't know how, as a police officer, you don't know how to get a firing pin for a shotgun. It's so easy that anyone can do it. It just takes a couple of seconds. But if you can't find one, you don't even know if they're available. I think the defense was not aggressive enough with that. What do you guys think?
No, they definitely could have pressed that a lot more. And you bring up a good point about non-functioning firearms. It does definitely changes the classification of that item. It goes away from being a firearm to, I think you said trophy item or relic.
Paperweight, man.
Paperweight.
Let's say I've got a Ma Deuce machine gun, belt-fed machine gun in my living room, but the barrel's leaded up and the mechanisms, the action is welded shut. What is it?
Yeah, it's at that point it's just a
statute. There's nothing illegal about that at all.
No, not at all. Not at all. No, I think you're right. The defense could have pushed a lot harder on that, given the fact that now he's admitted that they have a non-functioning item. That again, like I said, it changes the classification on that, state and federally. It changes the classification of it. Now, if they found the firing pin in the house or the firing pin in the box where it had been removed by the person, then that's a different thing. But since it doesn't have a firing pin on it, they don't know where the firing pin's at. Can they actually prove there was ever a firing pin in there in the first place?
I would have liked the defense attorney to just ask the investigator straight up. So you didn't look for one? No, I didn't look for one. Did you research, see how available they are? No, I'm sure they're everywhere, though. I would think. He kept saying, well, I would think. Nobody's paying you to think here. You're an investigator. You're supposed to bring some facts. I think I would have challenged him. The fact is, like, wouldn't you think that if you're going to challenge man's liberty as an American, that you would have at least gone and checked to see how reasonable it was for one to obtain a firing pin, making this a functional firearm? Because in your own words, it's a non-functioning firearm as it sits right now. As you found it, it's a non-functioning firearm. Now, the way the law reads is it's something that can be readily, quickly done. That's why he said just takes a couple of seconds. He's talking law. Just takes a couple of seconds. If it can be done quickly, then that's not an inoperable firearm. It can be considered operable. But the fact that the firing pin's not there, this shotgun's almost 90 years old. And the investigator can't tell you how, these are made. I looked them up online, and there's like several places that make secondhand ones, right? I can buy a dozen for 39 cents because they're not very big. Right. Or say that plenty of YouTube videos. I've seen a couple of YouTube videos that explain how to do it. But he didn't go any. I just don't think the defense attorney, because if he beat that, if the jury's like, I'm not sure if that was an operational weapon or not, this is over.
Yeah, it definitely puts that reasonable doubt there.
Yeah. What do you think about that, Fred? You've been quiet.
Yeah, you hit the nail on the head with your last statement. The word that keeps popping into my mind is inoperable, and the other statement made was no firing pin, not one in the box, not one found.
Right, but go with the theory that shotgun doesn't have a shotgun shell. You didn't find any shotgun shells at the house. You can't say it's a worthless weapon because it wouldn't be difficult for one to go get shotgun shells, right?
Sure.
So you could make the same argument with a firing pin. Well, the firing pins are easy. I can order them offline. This type of breakover shotgun uses kind of a universal style. There's several aftermarket. Come up with an answer. Have an answer if you're going to go to court. If you're going to investigate, have an answer. Let's say it's obsolete. Nobody makes anymore. You'd have to hand make one. You have to craft one. Gunsmith it. Well, that's not reasonable. The average person would do that. I would say you're leaning towards a non-functional firearm. And then I just saw a comment. If it doesn't function, it becomes a novelty. Oh, I thought she said Big Ron was a novelty. My bad.
No, that's true. I am quite a novelty.
But she's right. It's a statue. It's a relic. Relic is a bad word. It's a paperweight. It's whatever you want it to be, but it's not a functioning firearm. That's kind of the point. So anyway, we'll see if they pick up. We've got next week, we're going to have a gentleman from the ATF. He's going to talk about this firearm. We'll see if he can do a better job and see if the defense picks up on it, because they're going to come back to this again. I think I can own a Shockwave style firearm in Texas because it's not technically a shotgun. It's considered a firearm in 44. I don't even know what this is. So
4473 is your standard check form.
If you hadn't noticed, that's Range Minded. If you want to know about anything 2A, Range Minded Podcast is your guy. In fact, you know what? We've been a little sideways here with this broadcast, but let's don't get too sideways. Let's talk about some Range Minded real quick, since he wants to talk about federal laws on my state case.
Have you ever wondered to yourself, man, what time does the store close? Or where's the best cheeseburger near me? Well, I'm not going to answer those questions. That's what your damn phone is for. Use that. Instead, if you have stuff related, to the 2A world, I'm your man. My name's Steve. I run the Range Minded Podcast. On the podcast, we talk about all things Second Amendment, whether it be new guns or gear. Maybe we talk about some training. We'll dig into Washington and the shenanigans they get up to. Sometimes we talk about the Supreme Court and the crap that they're doing. It's always a good time, a little smorgasbord of the 2A, if you don't mind me using that narrative. Either way, you can find us whether on YouTube or Rumble, Range Minded Podcast. I'm also on all sorts of streaming services, wherever you listen to your podcast, Range Minded Podcast. You can jump on the website, rangemindedpodcast.com. Maybe stop by, buy a patch and some other things. There you can link to the social medias and all that other stuff. Hope to see you there. It's always a good time. Anyways, you guys have fun, stay safe, and always stay range minded. See you guys soon.
There you go, folks. The Range Minded Podcast guy puts out great content. He does it on a very regular basis. He is nominated for a Grundy, which is, I think, podcasters, 2A personalities realm, a Grundy for Micro Podcast of the Year 2025. Go to the Grundy website and vote for him. Make sure he gets it. And as Carmen Love says, stay range minded. Guys, let's get some final thoughts, and then let's clean this up and get into a space. Fred, you have any final thoughts, sir?
No, I just I'm real disappointed in this guy. Like you said, I don't really care what he thinks. I just thought it was pretty sloppy. That's it.
Yeah, have you caught the first episode?
Did I see the first episode?
Yeah, you should catch it. It's on the YouTube, my YouTube page under the lives. You should go back and watch next week's. And neither this is the longest one we've had. The last week was we were done in 45 minutes, I think.
Right.
Or less.
Right. I was here last week.
Oh, that's right. Actually, I forgot that you were here, but I'm glad you've seen it. So what
Thanks,
do you think of what compared to we had an investigator on the stand last week from a different sheriff's office there in East Texas. Which one?
Well, they were looking for the evidence, additional evidence from the original crime scene. Is that correct?
I don't
Last week, they were trying to track down some related items.
I got your question. What they're doing is they're laying it out chronologically. Like, well, how'd you get there? Well, we got there because there was a burglary in Smith County. We had evidence and information that the actors were in Van Zant County driving a very particular vehicle and could be in this area. So they drive to that location in Van Zant County. By the way, this was a high-end burglary. There was a gentleman's coin collection that the guy literally started collecting since he was a child. I'm serious. Like his father would give him coins, and he would collect them. He collected almost every coin he's ever touched his hands. But gold coins, some were worth a lot of money. But his house was broken into, and this was in Smith County. Well, that's a high-profile case. That's a lot of money. Whoever's doing that type of burglary, you want to get your hands on them. You know, they're not picking up cans of off out of the dollar store, right? I mean, they're breaking into houses and taking very valuable things. So they set out on that, and all this makes sense, and that's pretty standard in my opinion. They drive out to into Van Zant County, which is an adjacent county to Smith County where the offense occurred, and these are Smith County deputies. But they can go there; it's not an issue. You're investigating. You got the whole state of Texas. You can go investigate your crimes. But they're looking for a vehicle, and they drive by this location because they didn't know the address in advance. But they drive by this location, and they see the vehicle that matches the description, run the plates. This is the guy they're looking for. It's a whole different other person than the person that's being charged. So when they pulled down there, they don't have a warrant. It's like, hey, we want to talk to you, and start running folks real quick. And they might even had an arrest warrant, but they couldn't search with an arrest warrant. So they had a reason to be there. And it looks like through either plain sight or some admission that was given, they had enough to get a search warrant. So they write a search warrant, which you're going to have to get signed in Van Zant County because jurisdiction matters, but they have the authority to do so. And at that point, they contact Van Zant County Sheriff's Office. They call it a courtesy, but when you're going to start hanging paper, you better let the sheriff know that's about to happen. So Van Zant County sends their investigator out, evidently their lieutenant out there, who was the second guy who investigated. The first guy we listened to was the Smith County. He talked about how Smith County got there and what Smith County did. If you'll pay attention in his testimony, he's very clear about we had nothing to do with the gun. I was just there when it was found. But we asked Van Zant County if they were interested in it, and they said absolutely were. It was seized and found in what they believed to be in accordance with a lawful search warrant that was written. So everything seemed to be fine. So Smith County takes the burglar, even recovered some rare coins, some gold coins, and leaves there. But they never charged the guy who's on trial now with anything with a burglary. He's only been charged with a short barrel shotgun, which was discovered in the furtherance of an investigation for a burglary by another county there. And they're talking about the two structures. Understand that what we got is a double wide mobile home, and you've got a travel trailer that's pulled up back to it. And I think what they're doing is that they're either sharing sewer or they're sharing water. That's why they're close together like that. They're sharing a utility, most likely sewer there. And so somebody's evidently living in the double wide trailer. Somebody's evidently living into the travel trailer because both of them, it's parked like that. They're not very good at explaining it. But what they're talking about when it's pulled up there, but it's really close. The reason it's close is so they can put a Y on there typically, and they can run and share the septic. This is a very rural area in Texas, and that's actually not uncommon. But you're going to hear that. The next guy that's going to come in is going to be an ATF guy. He's an ATF investigator. They got involved into this because it's a firearm charge. I'm not sure to what depth. It could have been just for his expertise to prove that, hey, yeah, this is a non-functioning firearm. So maybe they'll clean it up with the next guy. But the two deputies we've heard, in my opinion, yeah, they could have done a better job. But I'll tell you, the defense attorney, in my opinion, could have done a lot better job. The defense attorney could have exploited some things there that I think they let lie.
Yeah, I totally agree. He seems to not be aggressive enough, in my opinion.
I don't know if you need to be aggressive, but you need to ask. Don't be afraid to ask a question. That's kind of
Poor choice of words. He needs to follow up a little bit more.
You know, and I think when it comes to firearms, I don't think that attorney knows enough about firearms to even ask the questions. I've heard me say this before, but money will get you a defense. And honestly, a lot of times you get what you pay for. And it's not that the attorney's a bad attorney. How much time is he going to spend doing the research on your case? You know, how much time is he going to spend? Like, well, I don't know a lot about firearms. Let me watch some YouTube videos. Let me find out how hard it is to get this. How available are these firing pins? You know what I mean? Because the attorney didn't know either. So
Right.
Either way, it's interesting, and the trials can change. Remember, you're seeing just what the jury sees. The impressions that is left with you are a lot probably what's happening with the jury at this time. The only difference is the jury's not allowed to discuss it until deliberations. We're going to loosen that rule on the night court show. We'll talk about it a little bit, but I've got a special at the end of this. We're going to tie this up real nice and neat. When we actually seat the jury, I think we're going to parade the evidence in front of you again, as prosecutor and defense would do. I think me and Big Ron are working on that, but it's going to be fun. Bruce Wayne, any final words?
I think you guys all summed it up pretty well. I don't think I have anything to add. But I am looking forward to seeing how this pans out next week. I'm definitely going to be tuning in and following this closely.
Big Ron, anything before we go?
No, I think we've hit all the important points tonight. I do agree with you. I think the defense is kind of doing a lax job, and we've seen that before in some of the other court cases that you and I have watched, Joe, where it seems like the defense just doesn't hit the nail where they should. Where you and I have seen them, we're like, why didn't they bring this up, or why did they miss that? And it seems really obvious to us. I'm hoping maybe they've got a defense that it's just we don't know what the defense is, but I agree with you. You get what you pay for. Maybe this guy's a public defender and, he's assigned by the court. I'm actually kind of curious. I'd like to know that if he was assigned by the court, he was court appointed, or if this guy's.
Well, let me tell you this. I hear that a lot, but in these rural counties in Texas, for sure, these attorneys that work in these rural areas, that's where they make all their money. Most every one of their cases are court appointed. If they're not on the court appointed list, they're not going to eat because there's not enough money in that area to pay a defense. So I think that they get a pretty adequate one. What it is, you got to run numbers though, right? You're not making big money, but you're making enough per. So you got to be running numbers. This guy the day before, instead of prepping for this trial, like it would be if you were paying some real money, this guy was probably working the jail chain as they come in on arraignments, right? On the 6 or 7 clients, he'll be there all day with a clipboard and pad and paper. And that's where I've just been assigned to you. I'm your attorney. So you start talking, then you go back and forth to the DA. The guys work. So I don't know that it's necessarily that. I think it's how much time can you buy, because you need some of their time ahead of time. And you know what? I see a lot of trials, and I see sometimes where I can see the strategy as to why that, you don't want to open doors, right? If you're the defense attorney. If y'all ever heard my Donnie Poole story, that's the best one ever. You don't want to open. There's some doors you want to keep shut that they can't talk about it unless you start talking about it. But I'll go back to the firing pin. It is 100% not too difficult to press him more about how much he didn't know about where he could get a firing pin. If it's so easy, where would I start to look? Did you look? Don't you think it would have been prudent, if you're investigating and prosecuting a man for this, that you would look to see how available these are? Can you 100% say here that they're not available, that this is not something that's obsolete, that it would have to be handcrafted? And there's a lot of ways you get to go with that you're not opening a door that's going to damage your client. And that's where I'm going to leave it. Folks, we'll talk about it more in a space. Give us about 20 minutes and I'll kick one off. We'll do a little after party for the night court tonight. And I got to figure out where my production went wrong tonight. I promise I'll get it fixed, but appreciate each and every one of you guys. Thank you.
Thanks, Joe.